joining us for our Oregon Law Commission work group on appeals from justice and municipal courts. We have a growing group, which I take is a great sign. We've got people interested in this and ready to share their expertise with us, and that will definitely help with our final, our proposal to the Law Commission, which may then go to the legislature. We have been recording the meetings of this work group, and so those of you who are new to us, hopefully you have gotten an email that has the link to the recording from our last meeting. If you haven't gotten that, we will resend out the links to the recordings of the last meeting and then to today's recording, so people can come up to speed. We do value your time, and in the interest of keeping things moving, we'll have folks who weren't at the last meeting go and review that. Hopefully you will also get Krista's summary of the decisions that or the issues that we talked about and some of the decisions that we made there. But we do have new folks here, and so if we can, we'll just quickly go around and just identify ourselves so people know who's on the call. My name is Rebecca Duncan. I'm a member of the Law Commission. I am serving as a co-chair of this group with Krista Obold-Eshelman. My role is as the commissioner to facilitate this group and to help us develop something into proposed legislation. I am not an expert on municipal and justice courts. My work was in the circuit courts and the appellate courts, and so I'm really grateful that we have the expertise of those of you who are in those courts regularly. And I'll turn it over to Krista, and then when she's done, we'll just go through folks in the order that they're on the screen. Krista?
Thanks. Krista Obold-Eshelman, co-chairing, and I practice juvenile appellate laws as a public defender, and I'm happy to have all the expertise here today. I will pass it to Justice Britton.
Hi, everyone. I'm Juliet Britton. I'm the presiding judge at Beaverton Municipal Court. I've been there for about 6 years now. I'm here in my capacity as the Oregon Municipal Judge Association president. Happy to be here.
I'm Karen Brisbane. I'm the Justice Court Judge in Clackamas County. We've been open since 2010, and I've been the judge here since that time. Before that, I was a practicing attorney for 30 years.
Maybe I'll just call in folks since we're probably not all in the same order on each other's screens. Lindsay, you're next on mine.
Hi, everyone. My name is Lindsay Detweiler. I'm an attorney in the Office of General Counsel at the Judicial Department.
James Brewer, Jimmy?
Jimmy Brewer. I'm an appellate public defender at the Office of Public Defense Services.
Tony Rostad, or Rasta.
Yeah, hi there, everyone. Tony Rasta. It's Rasta. I am a retired lawyer as of about a couple of months ago. Sean McCrae asked me to get involved in this because I have a lot of experience in municipal court, particularly Eugene. My partner and I were the primary public defenders for parts of decades in that court. And I've practiced also in Springfield Municipal Court, and I think in Junction City a little bit. So happy to add whatever I can to the conversation.
Great, welcome. Thank you.
Thank you. Thank you.
And then we have Jessica Minifee.
Hi, everyone. I am a senior deputy at the Office of Legislative Counsel, and I'll be ultimately preparing the draft that will become the bill.
Thank you for all of the drafting you've done so far and in advance for everything you'll be doing. Justice Cross.
Hi, Dan Cross, Judge of the Washington County Justice Court, where I've been the justice here since 2017. Before that, I was a criminal and juvenile defense lawyer for about 25 years, I guess.
Bill Golden.
Hello, everyone. My name is Bill Golden. I am a senior deputy district attorney here in Clackamas County, DA's office. I lead our misdemeanor unit as well as our juvenile unit, and I've been a prosecutor for about 21 years.
Thank you. Welcome. Jordan Hooper.
Hi, I'm Jordan Hooper. I work with OPDS, deputy attorney in the soon to be renamed trial division. But I'm here in my personal capacity as a lawyer a defense lawyer who used to practice a lot in municipal courts in and around Lane County.
Thank you. Is it Linda Hukari?
Hi, my name is Linda Hukari. I'm the trial court administrator for the Marion County Circuit Court.
Welcome. Thank you for joining us. Judge Patno?
Yes, Chris Patno, Justice of the Peace in Gillum County, Oregon, North Central Rural, Oregon. I'm also the president of the Oregon Justices of the Peace Association, and I am a non-attorney judge who has been on the bench for 20 years.
Great. Thank you. And Mr. Powell?
Hi, I'm John Powell. I'm the trial court administrator in Klamath and Lake counties.
Paul Smith?
I am Paul Smith. I'm a Deputy Solicitor General in the Appellate Division at the Oregon Department of Justice.
Judge Kidd?
Hi there, Justin Kidd, Marion County. I've been here for 2 years. Before that, I was at Oregon DOJ in the Civil Trial Division.
Appellate Commissioner Nass? Oh, I think we have your sound off.
Sorry about that. Good afternoon. My name is Jim Nass, former legal counsel for the Oregon Appellate Courts and later appellate commissioner for the Oregon Court of Appeals for about 35 years.
And then we have Patrick. And let's go to Victor.
Hey, good morning, everybody. Victor Ruther, Office of Legislative Counsel. It's good to be with you all.
Thank you, welcome. And then Scott Winkle.
Hi, I'm Scott Winkles. I'm the League of Oregon Cities lobbyist for courts and all things public safety and other stuff.
I think that's everyone. Thank you again for joining us. What we are doing, for those of you who are new, we're working our way through a draft bill. And you have received copies of the draft bill with questions in the margins. The group's going to go section by section through the draft bill. We're looking for your thoughts on the draft. There's some particular questions set out. There was some emails about what are the policies driving this effort? What is the goal of this effort? The goal of our effort is to take a look at the statute that govern appeals from justice and municipal courts to see if we can clarify them and simplify them. That's our primary goal. There may be some things around the edges that we touch on, but that is our primary goal. And so one of the things we've done in working on this draft is if there's differences in how certain types of cases are handled, we ask why. We ask, well, okay, if this process exists for this type of case, should it also exist for another type of case if that process is something that makes it more efficient? Nothing in the draft is written in stone. We've called you together because you can help us understand what is done currently, what works best, and where improvements can be made. So please do hope that you approach the draft with that understanding that this is something that we want your input on. A couple updates from our last meeting. At our last meeting, Appellate Commissioner Nass and Judge Kidd, and I know there were a couple other folks who were involved in this, we're dealing with Section 1, and we decided to send that group off to talk about Section 1. Section 1 concerns jurisdiction of justice courts, and the statute was a little cumbersome. So they have met and they have come up with a draft, and we can circulate that to this group. So keep your eyes open for a revised Section 1. We're not going to talk about Section 1 today, but we will talk about it at our next meeting. So take a look. So you'll get a copy of a proposal for revisions to Section 1. We'll take that up. You've also received a summary that Krista has prepared from our last meeting. We hope you'll have a chance to review that. There were some, make sure it comports with your understandings. Krista based it off the recording. So we do have we have all of that material. So it highlights the decisions that we made last time. It also flags some assignments, some of which I know have been completed because Lindsay secured trial court administrators to join us. And then, so take a look at that and see, there was a research question that we have posed for Jessica, and she'll follow up with that. Jessica, I don't know if you have anything to report now, or whether it's something we take up at our next meeting.
Yeah, I can provide a kind of unsatisfying answer. The question that I was looking into was the use of the term public writing in what was the basis for section 4, which is currently ORS 51130. And it basically says that the case records of a justice court are public writings. And we were trying to figure out, is that a reference to public records, or does that have some other meaning? So I looked into that. The use of the term public writing in that particular statute predates the existence of the Oregon Revised Statutes. So I wasn't able to find the exact history behind that, but I did find a case from 1961 that discusses early versions of Chapter 192, which is the public records chapter. And that used to have a reference to public writings, and it basically said every citizen has the right to inspect public writings. There's some nuance currently as to whether public writing and public records are synonymous. In some statutes they are, and one seems to be the subset of the other. But based on that older case, it seems like the term public writing, at least back then, was used to refer to public records. So I think it's safe to conclude that use of the term public writing in section 4 and ORS 51130 was really meant to make sure that that was disclosable as a public record.
Any reactions or discussions in response to that information? So this is going back to section 4 and that sentence Jessica mentioned. Any thoughts on a possible phrasing change, which would just be such case records are public records, and then possibly we would say for the purposes of the public records law?
I think that sounds clean to reclassify it as public records. Thanks, Jessica. That was interesting.
Can you give us a case citation for your 1961 case, please?
Sure. It's McEwen v. Holm, 226 OR 27.
Thank you.
That's something that we can have people think about, and we can take that up as we'll mark that as something we want to put on the agenda for the next meeting, and people can take a look at the case, think about this, and then take a look back at section 4. That sound okay? Okay. So that brings us to section 5. Section 5 of our draft concerns transfers to the circuit court. Under current law, ORS 51.050 sub 2 says, in any justice court that has not become a court of record, a defendant charged with a misdemeanor shall be notified immediately after entering a plea, if not guilty, of the right of the defendant to have the matter transferred to the circuit court for the county where the justice court is located. The election shall be made within 10 days after the plea of not guilty is entered, and the justice court shall immediately transfer the case to the appropriate court. Can those of you in the justice courts, on the bench or practicing in those courts, does anyone want to tell us a little bit about this transfer process, how frequently it's used, how it's done, how concerned we should be about transfers? When I was looking at the draft, I did wonder, why are we concerned about transfers? We're concerned, and I think the answer was, we're concerned about transfers because it is possible that if someone knows that they want to get to the circuit court, it is possible they could just elect to transfer, and then you wouldn't go through the local court, you wouldn't go through the justice court, and just go directly to the circuit court. There could be some efficiencies there if, as far as appeals, because you don't need to appeal because you never had your trial in the justice court. I think that's how come this section is in the discussion of appeals. So that's the background of it. But what can people tell us about the transfers on the ground?
One thing that might help as we sort of frame this discussion is it's currently just misdemeanors. And most justice courts do not handle misdemeanors. It's a very small minority of us that actually do that. Many of the courts, particularly the bigger courts in sort of the valley, are specialist courts in violations. So it's not something that comes up a whole lot now. I know that this may be a later discussion, but a lot of us are concerned about the language around transferring violations because there are inefficiencies that happen when there are transfers and cases get sort of handed off in a poor way sometimes, or there's just a lot of sort of officer no-shows that can happen when things go in a lot of different directions.
Yeah, I'm puzzled why violation would be included on this when it hasn't historically been the case. Doesn't seem like that makes a lot of sense because large parts of what courts like mine do is to make sure circuit courts don't have to deal with these types of matters. And of course, if we're talking about the appeal process of a violation and the availability of the appeal process from this court to a circuit court, we can certainly discuss that, which seems to be more focused on what this group was and then intended from the start. I think we're starting to branch out way beyond the original scope of this group, and I'm having some concerns about how far reaching we're starting to get. But I think the phrase "a violation" should be removed from the section. The misdemeanor is the one, and even my understanding because again we don't do misdemeanors in my court. The DA's office chooses not to file them here, which is fine with me. Okay. Because that's the DA elects where to file those misdemeanors. The courts, my understanding is the justice courts that do hear misdemeanors actually have a pretty small rate of those like getting appealed. But Judge Patno's better suited than I am to address that.
I want to go back to the original question: was courts not of record that handle criminal cases and the rate of transfer on those? And in my court, I do not have a high rate. However, I always appreciate the fact that I, preside over a court not of record. I'm dealing with criminal cases. I want to make sure that those before me have a right to have the case transferred to a court of record if they so choose. And we have a mechanism for that, and I think it works well on the misdemeanor side. So that's my input on the misdemeanor side. And I would also contend that the violation transfer, I think at times if something isn't broken, we don't need to fix it. And I think this is not broken at this time. We do have a way for people to appeal violations, and that's my input.
I agree with the comments of my three colleagues, and I believe that the misdemeanor transfer has been in place for so many years that probably those that have been practicing a long time remember it's only been misdemeanors, but that's what they can recall. The municipal or justice court that's not a court of record would transfer that misdemeanor if the defendant chose to. And I think the reason for misdemeanor transfers is there are different consequences for a defendant. In a misdemeanor, their liberties at stake. In a violation, they're exposed only to the penalty of a fine. And I believe that's probably the basis, even though most of it was in place when all of us started practicing, that misdemeanors could be transferred to circuit court. And I would agree that continuing that would be appropriate, but not violations. And then if you start talking about violations, you're talking about hundreds of thousands of cases as opposed to a lower level number of misdemeanors.
And just Clackamas handles misdemeanors.
The justice court's not handling misdemeanors, but I have familiarity with it from my private practice. And there's 12 municipal courts in my county, and I'm familiar with the ones that are and are not courts of records. that transfer misdemeanors to circuit court.
Okay. So is it more common for the municipal courts to have misdemeanors than the justice courts, or?
Well, there are more, there's only one justice court in Clackamas County, and there's 12 municipal courts. So in that sense, yes, there are. But 3 of those courts are also courts of record.
Okay.
So we have a mix in Clackamas County, but yes.
I think in Washington County, Juliet, isn't Beaverton the only municipal court in Washington County that does misdemeanors?
Yes, so I'm just going off the top of my head. So we have approximately 120 municipal courts in the state. And I can only think of, that's what I was doing while you all were talking. I can only think of maybe 13 or 14 municipal courts that handle criminal cases.
Okay.
So the vast majority of municipal courts only do the violations, including traffic, code enforcement, boating, that kind of thing.
Okay. So when we talk about transfers, it is a small portion. There's not, most of the courts are not handling misdemeanors. And so it's just a small part of the docket for both justice and municipal courts. For whatever reasons, municipal courts have been, or misdemeanors have been transferable. No, it seems like everyone is okay with maintaining that, but no one is interested in creating a transfer process for violation.
Correct.
Looking around, I know we don't have Heather Merrick from Legal Aid on this call, and some of her comments in the written materials, reactions to the earlier drafts, had talked about sometimes it could be easier for people to get to the circuit court, but I can't.
I will just comment on that from rural Oregon.
Yeah,
I'm sorry. From rural Oregon is absolutely not easier for people to get to circuit court because it's only open twice a month. I'm open daily. And I'm positioned where our freeway is, and it's an 80 to 100-mile round trip for people to get to the circuit court just twice a month. So just for our little court, that argument doesn't apply. So thank you.
It also doesn't apply in our Southern Oregon cities where the municipal courts are much closer to where the residents and the police department are located versus county seats. So yeah, that's absolutely geographically not correct.
No. I'm 10 miles at most from the Washington County Circuit Court. Judge Brisbane, I know, is not that far from the Clackamas County Circuit Court. So that's a negligible travel distance there. Judge Kidd is not that far from the Marion County Circuit Court.
No, we're both basically in Salem. I'm 100 yards from the Salem city border.
You know, so and quite frankly, it's the much of that is controlled by the where the officer or the officer's department elects to file the citations. That really controls where the proceedings take place. So
Any
I'm sorry, Justin.
no, go ahead.
I just wanted to chime in. Somebody mentioned that violations are there's no liberty interest because they're only fines. That's true, except that there's also the possible consequences for like license suspensions, driver's license, hunting, fishing license type things. So there is a little bit more to it than just monetary fines.
Right. But it's not a liberty interest.
Right. I agree with that.
Right.
There can be a liberty interest, but if you want to go to the extreme, you know, you can actually take somebody into custody if they fail to appear for that matter and issue a warrant. If I did that though, the Washington County Sheriff's Office would start picketing my court, and because they can't possibly handle that in the jail that they have, even though it's big jail. So I'm just saying that as a practical matter, we don't issue any warrants from this court for people to be taken into custody, period. So the chances of a liberty interest coming into play are really remote.
Okay. So that is the section 1 of the transfers and hearing consensus around what I described, which is not adding violations. It would be misdemeanors only. And as far as the transfer process, just as Patnote said, it's working. I don't know of any need that we need to specify any details about the transfer process. We will be specifying details about how the records get processed for appeals. If that's a good process, maybe, you know, that's the same courts will use. It doesn't sound like there's a large number of these. I'm not seeing a need to specify a process, but that's a question.
I just have one comment on the format. So the header of this section says appeals from justice courts. Section 5 says transfer. Those are two different things. I think transfers should be in a separate section. Even in this conversation, people are using that term interchangeably and they are not the same thing. And so I just want to highlight just kind of the format of it. I really feel like transfers need to be separate, so there's no confusion on the appeal process that we're probably going to really get into the weeds on versus the transfer.
Yep. So not hearing any need to specify a process.
Justice Duncan?
Yeah.
The only thought I had, actually, a question. What happens to the record of these cases? Does the Justice Court clerk physically transfer the citation over to the circuit court? Do we need to say something about the same way we do with appeals, that the clerk of the court would have a duty to transfer the record of the case over to circuit court within a certain number of days?
So in answer to how it works, we literally just put it in an envelope and send it across town.
It's already specifies shall immediately transfer the case. When we move a case from our court to circuit court, we have a courier that delivers things between the court systems, and so immediately is, I think that's self-explanatory.
If we're going to use the same process in that and the appeals, could we just define the term transfer somewhere in the statute?
How about if we, instead of just using the word the case, use the term the case record?
Well, those are two separate things, actually, although they're quite related, obviously. So if you want to do that, I would suggest say transfer the case and the case record to the appropriate court.
How does the case differ from the case record?
Well, anybody can come in and get a copy of that case record that's a public record. I mean, you know, the case is the actual litigation, the adjudication, the parties making the decision. Case record is simply the paperwork involved.
Maybe because this one is on transfers and we're not, and it seems to be working. Maybe we can leave case for now. Unless there's a strong need to specify a process. And I think if we have a good process for how the materials move in appeals, and that's a good process for the courts, they'll do the same thing. Or whatever they're doing now seems to be working and there's very few numbers.
I think what we're doing now works. I think it's clear, it's immediate, and we're transferring what we have in the case at the time of the election to transfer.
So let's maybe
For the case.
the whole case. So this
Yeah, it's the case, yes.
So that'll be our, we'll do that. There is a terminology issue I want to flag for everyone, but especially Jessica and Victor. At points in these statutes, we refer to justice as the person, so like the justice, the acting presiding officer. And sometimes that seems appropriate, other times it seems like we actually mean the justice court. Here is one of them where it says, the justice shall immediately transfer the case to the appropriate court. I would assume that we mean the justice court, but maybe we can just put that on a list of terminology that we want consistent throughout, or we at least want to be mindful of whether we are talking about the individual versus the court, and this seems to be like the institution of the court here. Okay. That's section 5.1 today. I'm both looking down and up, so please just raise your hand, but also just holler out, Jimmy.
One very minor thing, but in subsection 2, where it says the same right to appeal the circuit court's disposition of the charges, I wonder if that might not be better orders and judgments, because when the state's appealing, they're typically not appealing the disposition of the charges, they're appealing some interlocutory order.
Okay.
Probably comprehensible, but it might be more precise if we say orders and judgments.
Okay. So yeah, now that would be in section 2. Oh.
It's subsection 2 of section 5.
Yeah, subsection 2 of subsection 5. And Jimmy, what was your proposed language there?
I would just say like orders and judgments, or orders or judgments.
Order or judgment. Okay. As if the charges were originally charged in circuit court. Yep, I hear somebody. Just
from a historical standpoint, I think the reason, going back to your why are we sometimes seeing justice and sometimes seeing court, when justice courts came into being in the 1800s, the justice was in charge of everything, including finances and the entire. In fact, one of our recently retired JPs was taking his money to the bank every day doing the deposit. So in our historical sense of our statutes, the justice is in charge of everything. And that's why they're referring to justice as a single word many times.
Yeah, I think that's absolutely right. And so now as we have the institution court and not simply the single person justice, we'll try and update it as appropriate.
Right, we're all for modernization.
So I would flag that sub 2 here is new. It's just a clarifying provision. What it says is if you do transfer, so if you started in your justice court and you went directly to your circuit court where you have your trial, then your right to appeal is the same as if you had just started from the get-go in the circuit court. It's our understanding that that's the current state of the law. This just makes it clear in this transfer provision what your appeal process is if you transfer and go through the circuit court and then want to go on from there.
Also, when subsection 2 was written, there was a possibility of transferring violations. Now that they're just misdemeanors, it definitely would be the district attorney, not the county council, prosecuting a misdemeanor in circuit court.
Okay.
I'm looking at your note there about why you chose prosecutor, the word prosecutor, because it might be prosecuted by different government officers, county council and DA, but county council is not involved in crimes. So,
so we can use the district attorney there.
I would. I don't know what Bill thinks about that.
Yeah.
That's currently the process when a case is transferred from over to us. That we pick up the misdemeanor as the charge, so it wouldn't make any difference in what we're doing now.
Okay.
We review the case and may dismiss it, but we would take up the charge, and the transfer is different than us filing a new case in them. So we accept the transfer.
Okay. Anything else on anything?
So have we decided to replace prosecutor with the state? Because isn't the state always the real party in interest in a transfer of a misdemeanor from a justice court to a circuit court? Do counties ever adopt misdemeanors?
I think that's a good question.
No.
So I was thinking that in a misdemeanor being transferred from justice court to circuit court, it would necessarily have to be a violation of a misdemeanor defined by state law. Therefore, the state of Oregon is the real party in interest.
And there's also a separate statute that states that the district attorney is the attorney for justice courts. I don't have the statute memorized, but there is a statute.
So,
You mean for misdemeanors, Judge? Because they're not the prosecuting agency for all violations.
Okay, here we go. Well, violations are included in the definition of a criminal matter.
Criminal matter.
Yeah.
Criminal matter, yeah.
I think
You gotta mute, Judge. You gotta mute.
Okay, ORS 156.520 states that the district attorney shall control the proceedings on behalf of the state. And that's in justice courts.
In chapter what? Where is that?
156.520, function of district attorney in justice court.
Since we've never been there, not familiar with that statute. Currently in Clackamas County, we do not have any involvement with justice court or Judge Brisbane's court. When there's a transfer of any kind of appeal from her court, generally we don't handle those. The officer that is involved with the case handles them because they're not misdemeanors. When we get misdemeanors from other courts, like our courts of record that are municipalities, those transfers come to us and then we accept them and then we prosecute them as a misdemeanor. But violations are not something that we traditionally get involved with. We wouldn't have the capacity to do that anyway. Not with as many that are filed in Clackamas.
Right, I agree with Bill's comment along those lines, but as far as which entity is involved with justice court, it would be the DA.
I don't quite read that statute the same way, Judge, I have to say. Because the language is the district attorney may prosecute an action,
right,
and if requested by the court, shall prosecute an action in a justice court and attend an examination before a magistrate, either in person or by someone appointed by the district attorney for that purpose. In any case, the district attorney shall control the proceedings on behalf of the state. Right. Yeah, there's a predicate function there which is not required.
Right, I agree it's not required.
So for example, my county, if there's an animal control hearing, that's prosecuted by the county council. If there's a noise ordinance violation, and where the defendant has an attorney there, that's prosecuted by county council.
Right, but if there's a misdemeanor transfer, it's going to be the DA.
Oh, absolutely. But I'm sorry, but there was a blanket statement made that I didn't think was quite reflected accurately by that. So
I defer to you.
When we say it's a misdemeanor transfer, are we confident it's only going to be a state misdemeanor defined by state law? And then sub 2 is talking about once the case gets to the circuit court and then you go up on appeal, we're identifying the government agency. And so the draft has prosecutor, but when we're talking about going from circuit court to the Court of Appeals, it seems like, Paul, that might be DOJ, and maybe we would use the term. So our options on the table are prosecutor, DA, state. For this, when we're talking about the rights of the government entity from circuit court to Court of Appeals in sub 2. So thoughts on, in light of that, Paul, that.
Yeah, I mean, I think if we're confident that the only misdemeanors we're talking about are violations of state law, then I think that should say the state shall have the same options to appeal, because under Chapter 180, I mean, only the Attorney General can appear on behalf of the state in the appellate courts. And so it wouldn't even be right to say the district attorney can appeal that to the Court of Appeals, because only the Attorney General can appear on behalf of the state there.
Aren't there some misdemeanors that are entirely though within the municipal code? They're not a state statute, and they're different than maybe a comparable state statutes. They have some additional tweaks or ways perhaps that the misdemeanor can be committed. And if so, does that mean that they would have to be prosecuted on appeal by the city attorney?
Well, and that happens. You know, I mean, I know some municipalities have adopted, you know, their own criminal codes. A lot of them mirror the state criminal codes entirely. And when an appeal from a conviction from, you know, of a Portland city code, for instance, you know, that should be the city attorney who is handling that on appeal.
So we're talking about who's gonna, basically in sub 2, we're talking about the entities that are gonna be involved at the Court of Appeals stage. For justice courts, which is what these sections relate to, sounds like that would be the state. But if we want these sections basically to be as close to what we would use from municipal courts, we could say prosecutor. We don't have to, we could say state, because we know that, or we believe that there's no non-state misdemeanors coming through justice courts. Thoughts? So I know this issue comes up, this prosecutor, city attorney, district attorney, state, DOJ, that's going to come up throughout our efforts. So
I wanted to point out from the Eugene Municipal Court, my experience in Eugene Municipal Court, those misdemeanors are under city law, city ordinance, and there are thousands of them. So you got to remember that Eugene is, if it's one of 12 courts that handle misdemeanors, there are still thousands of cases. And I don't know if on a transfer, I mean, the defendant can, apparently, if it's a transfer of a misdemeanor, the defendant already has a plea in, so the case is started under a city ordinance. So I would think the gist of that would be the word prosecutor should be used, because it could be a city prosecutor that appears. I don't know how they handle those transfers. I know how they do the appeals, but from the beginning of the case, it's a city ordinance in Eugene. That makes sense.
What if we leave prosecutor here and we start a running list of cases where we know that this terminology sections where this terminology matters, and then we'll review those, especially before we finalize. That sound okay?
Yeah, I like leaving prosecutor for now, because again, even if it's, whether it's a DA or a county counsel or a city attorney, we're all prosecuting that particular case.
Yeah, I know that this is a real issue when it comes to service, because we want the service of the notices of appeal to be clear as to who gets served. And then that is sometimes difficult to determine who is the prosecuting entity. So I know this will come up again. That is all I had marked for section 5. I know in Zooms it's a little awkward to just leave silence, but I want to make sure that if anybody wants to pipe up, there's an opportunity to do that before we move on to 6 and 7.
I just want to make clear, we are going to strike the reference to violation, correct? Okay.
Okay. Our next section is 7. 5 is 5 concern small claims, and then we'll be handling that separately. 6, we deleted to keep the numbering consistent with the earlier drafts. Section 7 is a big issue. And this is the court to which the appeal is taken, and really it is where, no, the next one is where the notice is filed, which is where it's a big issue. So section 7 is if the justice court in court of record, civil cases, it's a court of record, it just proceeds as the same as if the case started in the circuit court. That doesn't change the law. I think that's straightforward. So that's section 7 sub 1. Any questions about subsection 7.1? And then sub 2 just says, if you're not a court of record, the way you appeal is as we are going to go on in the rest of the draft and explain. So pause for a moment and see if anybody's got any reactions. I would flag that there's an issue about, people have raised an issue about which courts can be courts of record. I know Judge Cross, you've raised that issue. And with respect to the limitation on courts that are within certain number of miles of their circuit court not becoming courts of record, this draft doesn't engage with that. We're not taking that issue on here, but that was something people had raised, and maybe that's something for future discussion. Okay. Section 8 is the time for which the appeal must be taken. With it's 30 days.
Just a second.
Yeah.
I just realized that we don't have a section saying what one can appeal from. Oh, that's because it's in the other sections.
Yeah.
Never mind.
So our section 8 retains a 30-day time limit for filing a notice of appeal. I assume that that's fine. We do have a 10-day notice in current law for small claims, but we're going to talk about small claims separately. Section 2, subsection 2 of this section 8 talks about when your notice is due if there's been like a post-trial motion. So a motion for a new trial or a motion in arrest of judgment. In our smaller earlier group, people said these things don't come up a whole lot. They are possible. And so subsection 2 would add what is in the statutes governing appeals from circuit courts for when you have to file your notice of appeal if there's one of these post-trial motions. And so this is the same as the criminal process. We had our municipal court members, Judge Gill, Melissa France, and Judge Cross, and Heather Merrick from Legal Aid. All of those people who weighed in on an earlier version thought it was okay to add these deadlines for when you have these post-trial motions, which I would guess are not common.
I have a concern that may be bigger than we have time to discuss here, but my worry is that we are introducing sort of a loophole whereby somebody who defaults and therefore puts no claims or defenses in would have a way to get a brand new trial, right? Which sort of, in my mind, penalizes the plaintiff. And so I think that there is a reason that justice courts have a slightly different statutory structure. And I think adopting this wholesale may cause some unintended consequences that would cause plaintiffs just not to come to justice court.
in a civil case?
Yeah, well, particularly in a civil case is where, particularly like in the FED context is where it, I think, most bites,
Okay.
right? Because somebody, if you are a landlord and you've gone through the whole process and somebody's defaulted and you serve your notice of restitution, and all of a sudden they want a new trial, right? They don't get a new trial necessarily in circuit court, but in justice court, there is a way that we could write this that would kind of create that opportunity. And so, like I said, I think it's probably a bigger topic than we have time for today, but I have that concern.
Okay.
Justin, do you think it might be fixed by adding, and this is just again food for thought. We put, if a motion for a new trial or motion in rest of judgment is timely served and filed after a full hearing on the merits.
Maybe I think my idea is how we would limit that is I do believe that they should, that it should be that there should be some judicial review, but I feel like the judicial review needs to be carved out and be whether the original default was compliant with the law, right? And because my worry again is the creation of a brand new de novo trial right in a way that prejudices plaintiffs.
That's why I said after a full hearing on the merits, that would perhaps address that. Just something to think about. I'm not.
Yeah.
I don't think you're right. I think it's too big for this. Maybe today.
And sub 2 is taken from chapter 138, which governs criminal cases. So what if sub 2 is limited to violations of misdemeanors and doesn't affect civil cases at all?
I feel better about that. I still feel like it does. Yeah, it cuts out the majority of my concern. I still have some concern that people who just flat out don't show up, right, would be getting a brand new sort of do-over, which they wouldn't get otherwise, right? So,
okay.
But I feel better about it.
Okay.
And I agree, somebody who fails to show up should not get that unless they come in and actually file a motion to set aside the default judgment that's granted by the trial court. In which case, then after they're getting a new trial with you,
right,
or a new opportunity for a trial with you. But
Other thoughts?
We should strike what is now 3B. That's the reference to the audio or stenographic recording a party would have arranged to make. The decision of the work group is that if a party wishes to rely upon that record of proceedings in the justice court, they should do so by filing a motion after the case is already in the circuit court, and it shouldn't be just assumed to be part of the record.
what about, Jim, if the parties in the case, when they set that up and got the approval for the recording, they there's the provision, if I recall correctly, in the statute, the current statute, that says it can be, upon stipulation of the parties, the record in the case. Am I not mistaken?
Yeah, that's right. So in the justice court, the parties can agree that a recording is the official record. And so I think the question maybe in sub 3 is what happens, what do we do with those records? If that has happened in the justice court and you have this official recording.
Well, I think you have to send it over then as part of the case record.
All right, so sub 3 is dealing with when the appeal is perfected, and it says right now it's perfected upon submission of the case record, and this recording.
Well, oh, I'm sorry. Go ahead. I apologize.
Just that if there was one, not that there had to have been one.
Right. Yeah. No, I meant was it would be part of if that had occurred, if the statute had been that stipulation had come under the existing statute, and you wouldn't have to have the language of small b because it would be part of the case record. And if you just said the appeal is perfected upon submission of the case record, period, I think you've covered it.
Yeah,
but I do think that record would have to be sent over as part of that case record if that stipulation had occurred.
Are we sure that ORS 51.105 says that the recording becomes part of the record?
It only does if there's an agreement between the parties and the court.
Right.
Because I remember when we discussed this last time, somebody pointed out that because the appeal is de novo, the parties may not wish to, or at least the appellant may not wish to rely on that hearing because they're going to be able to call the witnesses all over again anyway.
Yeah.
And that's why the decision was to leave it up to the parties to move the circuit court to make that record part of the record on appeal if that party thought there was some good reason for it.
So I think there's at least two things here. One, what do we do if the recording is already part of the record? And in sub 3, we had said the case record includes these recordings, or at least we talked about saying the case record includes these recordings if, and it would be only if everybody agreed they're part of the official justice court record. To Judge Cross's point, if they're already part of the official justice court record, then we don't need to say anything here about the appeal being perfected upon transfer of submission of the case record and these recordings, because if they are already part of the case record, it's covered.
Yeah, I take it back, Justice. I don't think I was right when I said it becomes part of the case record. Because I'm looking at, now I'm reading 51.105. And it says, the parties can agree that the recording may be used by the parties during the proceeding, not that it becomes the case record. And then subsection 4 talks about it becoming, if all the parties agree, that it becomes the official record of the proceeding. But nowhere does it say that at any point in time does the court or anybody else get to submit it or review it in its entirety as part of the case record. So I think there's a difference there. And so I think the only question is whether it would constitute the official record for appeal purposes. But I don't think it's part of the case record. That make sense?
Well, if it was, what would be the point of having a trial de novo? It'd be more like a court of appeals review.
Well, that's the potential dilemma. Yeah. What is the appropriate appellate avenue if that becomes the official record?
Well, so you can have your case record. So if we're talking about once you're done in the justice court and you've had your proceedings there and you're going to the circuit court, this is talking about when that appeal is perfected. So it's talking about once everything's gotten to your appellate court, your circuit court. And so do we care if, so you're going to have a trial de novo. We're just talking about what's getting from the justice court to the circuit court. If you had a audio recording that was made the official recording by everybody's agreement in the justice court, wouldn't you just send that along? And wouldn't we say that if you all agreed that it was part of the official record, using that terminology, which is in 51, then it is also part of what we call the case record for appellate purposes. That makes sense.
There, yeah.
Sorry, it would be evidence in the case, but it's not like the decision that happened below is going to happen again. It's just evidence in the case for the de novo trial that happens in the circuit court.
I don't even know if it's evidence, because you get the de novo trial. It's just part of like, here's our fat paper file. It's like the equivalent of here's what happened below. You're starting over in the circuit court. It is my understanding that.
Yeah, I guess right. You're right. It would be potentially evidence if people would introduce it as evidence, but it would be part of the case record.
Yeah, and I think that's Jim's point. Jim is saying like, if in the circuit court, like let's say you had an officer testify in the justice court And the parties agree in the de novo trial in the circuit court that they don't need the officer to come in. They'll stipulate to his testimony that was given in the justice court. Then the parties in the circuit court pursuant to the de novo appeal, as part of that, they could say, we're going to just use this recording.
It's like a taped deposition.
Yeah, if that's, I think that.
Yeah, I think there are sometimes instances where the proceeding in justice court raises a purely legal question, perhaps a search and seizure issue. The parties fully litigate what happened in the justice court. Everybody's happy with the record made there. On appeal to the circuit court, there's no point in calling all the witnesses back in again when you already have a record that frames the legal issue that you need to have the circuit court decide.
Right, as long as, but then again, that's all the parties have agreed to that. I come back to the fact that I still think I'm hard pressed to call it part of the case record when it's not something that the trial judge ever looked at, reviewed, relied upon.
As a practical matter, I just don't think this ever happens, because especially in violations, the main way that a defendant wins on appeal is that the officer does not show up the second time because the case is scheduled in a weird time or something. So I don't foresee defendants ever saying, yes, I'll just accept your testimony, right? You don't have to set it up again. So it may be kind of a moot point, I think.
Right, but that doesn't mean we want to put it in a statute incorrectly. I've only had one time where I had a violation hearing that the parties agreed to have a court reporter take it all down. One time. But.
Well, that's my point though. Like, we may not need this because as somebody wisely said during the chat, this, it would be a statement under oath anyway. It's admissible to, we could just not put this in there. And to the extent somebody wanted to use it as impeachment or as other evidence in the trial, they can just introduce it as they please, like they would with the deposition. And that wasn't my thought. I don't want to steal that thought. Somebody else had that and it was smart.
I agree. I think it should just say that. I think we should just there should be no sub A or B. That three should just send it with upon submission of that case record.
Yes.
We can do that.
I'm just saying I don't think that this recording, if it was done, I don't think that would necessarily be part of the case record.
It is based on what we did in section 3 last time.
And I don't know that there's a problem with it being part of what we call the case record, which is, I think we're trying to say, just like the file that goes along.
Right. It just makes it part of the file.
How does it make it part of the file?
And section 3, subsection 1, it says that the case record includes the case file. And then in subsection 3, the case file includes the recording if everyone agrees.
I'm sorry, with the
in the working draft that we're working on.
You have to go back up to section 3. We're in section 8.
Oh, I see. There it is. So section 3, sub 3.
Right.
And there's missing language on the one of the drafts, but it also consists of any audio recording or stenographic recording or other recording, if all parties agree that it's the official.
No, what is there a difference between the case file and the case record? Because we use case record here in section 8, and we use case file in section 3.
Yeah, so I'm gonna
look in section 1, subsection 1, that is, of section 3.
So there's the case record and it has the register and the case file. And the register is like what we call, it's like the document, just the events. Right. And then the case file is all of the papers, filings, pleadings.
I come back to being just a little troubled by having a recording that was not reviewed or relied upon by the trial judge as being part of being kind of in the record as though it was. So I don't know, but if folks are comfortable with that, then again, I'm not the one that has to decide it. Doesn't come to my court. It's no skin off my nose.
I'm probably showing my ignorance here, and I've done that before, but doesn't are we talking about an audio record that was prepared by the parties, and the court doesn't even have that? That's a recording of proceedings in the justice court, right?
Correct.
And I don't think that the court doesn't even have that document, if you will. The parties keep it.
There'd be a transcript. More like the one time happened in my court, there was actually a court reporter who came in and took down.
So that effectively became a court of record in that instance.
Well, arguably, but the defendant was found not guilty, so it became kind of a.
And technically, it doesn't actually become a court of record because there's more process that's required to become a court of record than just having the proceeding recorded. Can we take the suggestion that the appeal for subsection 8 sub 3 or section 8 sub 3 appeal is perfected upon submission of the case record, and Dan will we can mark that you had questions about whether this tape recording, if there was one, should be included, and that relates really more to section 3. But we can follow up with that, but we would just leave it now, both as is in 3 and 8, but you can come back and with a proposed alternative or additional thoughts.
So I heartily apologize, but I have to go. But I think the issue on the default needs some more thought, and to the extent somebody wants to put together a sub work group, and maybe Jim would be like our honored like Sherpa on writing things in ways that make perfect sense. I would volunteer to work on that if you all so agree, or if you all think that's what we should do.
I think it would be helpful to have people think hard about what the current state of appeals are for defaults, and make sure that we're not doing anything inconsistent or unintentional. Jim, what are your thoughts on working on that?
Yeah, upon rereading this, I thought motions for new trial or motion in arrest of judgment, I thought were terms of art that are only applicable to criminal cases, which as applicable here would be misdemeanor cases, and that this wouldn't apply to either violation or civil cases. But it is true that in a civil case, you can have a motion for new trial. So I think at a minimum, we should limit it to misdemeanors. I don't know about violation. I guess I'd have to yield to the judges and litigants in justice courts. Do you ever get motions for new trial or motions in arrest of judgment in a violation case?
So our courts are for lay people, so they call things all kinds of weird stuff, right? And so I get things called motion for new trial all the time, which I sort of construe to be like a motion for relief from default verdict, right? Which I hear, but people because they're lay people, they're not going to call it what lawyers call it.
Okay.
And also, Jim, just to keep in mind, while violations are not crimes, they are criminal matters under the definition in the criminal code of a criminal matter. And so it's this weird, little territory that exists, but it is a criminal matter and therefore subject to many of the things and protections of the criminal code.
What's the statute that says that?
Is it 131-105? I could be way off on that, by the way, but
sorry, I have to go. Thank you, everybody.
You might be referring to 131-005, where it talks about a criminal action is a violation, a misdemeanor, or a felony.
Yeah. Yep, that's what I'm talking about. Thank you so much. Sub 6. 05 sub 6.
Oh, boy. Yeah, then I would concur that maybe we do need to have a subgroup that would at least think about this and see if we can make improvements and clarifications here.
And then we just, okay. All right. Now, this is all coming out because we put in a provision that says here's what to do with new trial. Okay, Jimmy, did you have a question? Comment?
So just 2 comments. First, the new trial. So this is just about the timing of when the notice of appeal can be filed. And that's the same in civil cases. It's ORS 19.255. It's the equivalent timing provision when a motion for a new trial is filed in a civil case. But it seems like the conversation we're having about what do you do when you appeal from a default judgment doesn't really fit. The concerns we have don't really fit with this statute, which is just when is the notice of appeal filed, right? And if you notice a default judgment within enough time to file a timely motion for a new trial, that's also time to file a timely notice of appeal within 30 days. So it seems to me that if there is to be a separate provision that limits the type of review that's available when you're appealing a default judgment, that I think needs to be separate from the question of when should the notice of appeal be filed when there's a motion for a new trial.
You're doing more of the question of whether or not you can appeal a default judgment. Period.
This is just the question of timing.
No, I'm saying that there's a I think that what gives any authority for a defendant who's in a violation case has been defaulted, or in a small claims case has been defaulted, to appeal that decision.
Right, and I agree. That's a question that should be looked into. But Section 8 is just about timing. Insofar as you can appeal a judgment, when should you appeal it?
Yeah, okay, I misunderstood you. I'm sorry.
Right.
Yeah, that's it. Yeah.
Okay. So we can in the follow-up email see if there's people interested in reviewing the default, the rules for appealing a default, making it clear what's appealable, if anything there, and then checking to see if any changes need to be in Section 8. Okay. We are at 1:19. We are scheduled through 1:30. We have to talk about our next meetings. We have one scheduled for September 21. We'd like to continue to meet. We'd like to meet just to keep, I know this is a blog and it's very detailed, but it's important that we have your expertise and thoughts. I think it would be great if people are available. What do people think about having these meetings every 2 weeks so that we can just keep momentum going? We can send out a doodle poll to get best times. Are there best days of the week? It usually seems like towards the end of the week is better for folks. What do people think about frequency and availability?
I am unavailable Tuesdays and Thursdays during lunch. So my preference would be a Monday, Wednesday, or Friday. If we could.
I think we should skip Monday.
I'd take Wednesday over Friday, but I can probably make it work.
I'll just say I'm generally unavailable the week of the 18th, but other than that, I'll be here.
All of the local judges, JPs and municipal judges, are at a conference the week of September 21st.
Okay. That whole week.
Well, Wednesday, Thursday, and Friday.
Okay.
I'm happy to participate with the group. Increasing the frequency will also increase the likelihood of me not being able to be here, but I can certainly.
This would probably be a good time to mention that for our tentatively scheduled meeting on the 21st, both Victor and I are unavailable.
And it sounds on the, okay, the 21st.
Is changing that date an option? I don't know. I'm just throwing that out.
Because the 21st is all that, the local judges, that conference falls on the 21st.
Right.
It does. It might be hard to get all our technology set up for a remote location.
Yes, that sounds like we will be missing essential folks, a lot of you, and so we will find it, we will, Krista, what do you think?
Well, could we do the 18th or the 19th that week? Or
Can we send around a doodle poll? How's the 18th look? For folks, that is Monday.
I won't be available on Monday, but I'm available on Tuesday.
I could do Tuesday.
I can't do Tuesday if it goes to 1:30 because I have court at 1 on Monday, on the first and third Tuesdays.
I'm sure there's going to be, with this many people, we won't be able to get everybody in the room. So
the 19th, I have something that's going to go until 12:30. We could start late, 12:30 to 1:30, but no, Judge Brittany just said to finish early. Okay, well,
is Monday the 18th the best option? Was there from almost everyone?
Since it's regarding justice courts, Judge Brisbane is important with her input, I believe. So that's just my 2 cents. She can't do the 18th, I don't think. Can you?
I'm not available because I have to travel to a second court for that date.
So Tuesday the 19th, Justice Duncan's not available, it sounds like.
Okay.
I mean, maybe into the week of
the next week.
27th is the following Wednesday.
I'm out of town, but could try and do it remotely on the 27th. Okay.
It will give us a chance. Excuse me, I apologize. Go ahead. I just wanted to say that since our Oregon Justice Peace, the Justice Peace across the state who deal with these statutes daily, I think it will be good to give a chance for us to catch up with them at our conference and see where we're at thus far, because it's, it will give us a chance just to catch up to Section 8, correct?
That's what we've, yeah.
Okay.
Okay. Yeah. I mean, go ahead and get their feedback on it.
Yes.
Of course. Okay. So maybe we will look for a time on the 27th, 28th, or 29th. I'll try and get my conference schedule and find an opening those days.
Justice Duncan, I'm unclear on the subgroup regarding defaults. Was your ask, so I heard Justin say if anybody wants to work on a subgroup, I'd like to, but then I didn't hear any follow-up from anyone else. So do you want me to set up a subgroup on that topic, or where are we at on that subject?
Can we hold on the default? I think there are later sections of this bill that talk about
Okay.
what you can appeal, and when we get to those sections, if it is just simply like, if you default, you know, you cannot appeal, that those may just come up and fit well there.
Okay, sounds good.
Okay. So let's, how about the 27th, but let's do 12 to 1 on the 27th. And I'll do that remotely, and we'll pick up on section 9, I believe. That sound all right with folks? And then maybe we will send, well, Krista will maybe send doodle polls for meetings after that, looking at Wednesdays over the lunch hour. Sounds like Wednesdays or Thursdays over the lunch hour.
And Chris, I'll create a link for the 27th date, and I'll also send you the recording of this meeting as soon as it becomes available.
Great. I heard Tuesdays and Thursdays weren't good, or was that just Judge Britton?
So it's not every Tuesday, Thursday, but I have a treatment court where I can't have another judge sub. So it's the first and third weeks of the month.
Okay.
Those are the hard weeks for me. So if we're looking at the second, fourth, or fifth weeks, I'm much more available of the month. And those court, it's all day with staffing. So that's why I like to just kind of block out the whole week.
Okay. Anything else as far as calendaring? We'll schedule the 27th, 12 to 1, and we'll get a doodle poll out for subsequent meetings. And we'll pick up with the review. Thank you again, everybody, for your thoughtful input and attention to all of these details. We appreciate it.
Thank you.
Thank you. Bye-bye.
Thank you.